another person will stand up if I think, after really going through this, and looking at the files and looking at the case, if I really feel that Karen Reed didn't do this and I have to be a voice that stands up and helps, I will.
We are expecting to learn more about the allegations against the girlfriend of a Boston police officer who was found unresponsive in the snow Saturday morning. I-Team sources say Karen Reed was in a relationship with John O'Keefe. She's facing charges including motor vehicle homicide and manslaughter.
We're the only ones fighting for the truth of what happened to John O'Keefe. And me and my family and my attorneys and my team have marshaled every resource to get to the truth. It just feels like no one else wants it.
Now, just be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
And no, she didn't do it. No, she didn't do it. This is an innocent woman. She didn't do it.
I tried to save his life.
Yeah.
I tried to save his life at 6 in the morning. I was covered in his blood. I was the only one trying to save his life.
Why'd you admit to it?
She didn't admit to it. She didn't admit to anything close to that. Nothing close to that. And you should know that.
That was like 3 or 4 times she admitted to it.
No, she didn't.
That's not true.
She asked a question. She asked a question, which is very different. She didn't admit to anything.
I'm going to tell you one thing. Karen Reed's not going to fold. Karen Reed's not going to give up. Defense team's not going to quit. The Free Karen Reed movement is going to continue. We will continue to raise funds for her. We will continue to do standouts across Massachusetts, across the nation, across the world to let everybody know what's going on here in the state of Massachusetts, the corruption. And we will continue to get the word out there. Believe me. Believe me. All right, everybody. Welcome in. A big day in the Karen Reed hearing. It's over. We're still waiting for some motions. Beb's going to rule on some motions, but we had motion hearings today, and we're gearing up to get ready for Tuesday's trial. I cannot believe we are here, and we are actually, it's going to happen, Karen Reed 2.0. But I think the Commonwealth is going to have another thing coming to them, to them. And we saw Hank Brennan have a meltdown today about ARCA, and I've said this all along. I feel and I know all of you out there, ARCA is the case because it proves that Karen Reed did not hit John O'Keefe, and John O'Keefe never made contact with Karen Reed's vehicle. What I want to do here is bring in some special guests this evening. Let's not wait too much long here. We'll get the conversation flowing. I want to bring in my long-term friend here on the channel, Mr. Todd McGhee, retired Mass State Police. Todd McGhee, welcome into Let's Talk Live.
Good to see you, Brian. Thanks for having me back.
Absolutely. And for the first time here on Let's Talk Live, we have Martin Radner. He is an attorney, and he has the YouTube channel Brother Counsel. And I want to bring him in for the first time as well, too. Hello, Martin. Thank you for joining us this evening.
Hello, Brian. It's great to be here. Thanks for having me on. And I got to tell you, when I come onto these shows, I always realize that I really have to have some sort of intro onto my videos also, because these intros are just so cool, I think, so I got to put something together on my channel also.
I appreciate that. We try to mix it up a little bit. Sometimes I have a little jazzy music intro, but usually my Karen Reed streams, we get the fight song going and we try to get everybody geared up. So what a day here of hearings. And I want to hear from Martin. Have you ever heard or seen any case like this in your entire life? I mean, this is wild. It's absolutely wild.
No, I mean, the answer is no. And no attorney in the world is going to tell you that they've seen something like this either. I mean, this is like a once in a lifetime type of case. Maybe when you're a high profile lawyer like Alan Jackson, maybe you will get a case or two like this in your career. But I mean, there's a reason why this case has gotten so much attention. And this is another reason why I think if you are a lawyer and you have a channel, aside from the other coverage that's going on, which is great, guys like you, Brian, but also if you're a lawyer specifically, I know that people are shying away from the Karen Reed case because it can really get toxic. People come after you. They try to say nasty things about you online and on Twitter and all this stuff. But if you're a lawyer and you're covering cases to help people understand what's going on, this is a case that you have to be looking at. This is a case that you have to be covering and trying to explain to everybody what's going on. And if you're seeing something that's odd, which I have seen a lot of in this case, you have to let people know about it. I mean, this is important because there's a lot of eyes on this case, as we were talking about before. There's a lot of eyes on this case nationally, internationally. People want to see how the justice system works in America, how investigations occur in America. And, if this is the impression that they get, that's not exactly what you want them to walk away with. So, we have to be out there letting everybody know if there's something that's odd, something that's not common, or that this is not the way it normally works, things like that. That has to be, that has to be brought to light. And by lawyers, people like Todd McGhee, and the police investigation experts. That's what the people like this have to speak up. So,
yeah, I agree. Todd, how odd is this case? How odd is the investigation in this case?
Never seen an investigation like this. I was active for 24 years in law enforcement. I still work within the court system as a use of force expert. So I'm still connected to law enforcement with some of the different litigation work I do. Nothing has ever reveal itself like this, like the shenanigans. I'll say, at least on the public safety side of things with the investigation. So lots to talk about. We'll be able to see the defense's hopefully new angle in trial 2.0. We'll start to see again the inadequacies of the investigation being pointed out. But I think this time, I like to use the expression, I think in trial 1.0, there was a meat left on the bones, so to speak. And I think this time you're going to see Attorney Jackson, Yannetti, and the remainder of the legal team really pinpoint and really dive in to some incredible analysis to just pick apart the prosecution's case.
Yeah. Martin, I want to ask you as an attorney, and then going into this and watching 1.0, watching that lead statement when, David Yannetti gets up and that great famous statement, Karen Reed was framed. Do you think that was a little bit too much for the jury? And do you think that they're going to tailor their defense this time around? And maybe, because I know that we talk a lot about it here, and I think, I did a poll in one of my last shows, or the second to last show I did, and I said, what way will the defense kind of lean this time? Are we going to go down that framed route, or do we just keep hammering home reasonable doubt? And before you answer, to let you know, I went back and watched the opening and closing argument from the defense. And I'm going to ask you, how many times do you think they said reasonable doubt in either one of those statements?
I would say 0.
It was 3.
It was 3 times?
3. It was
okay.
3 times.
I know it was very little because it's something that stuck out of my mind. And Brian, no offense, but I see that you're not following my channel so much, because I spoke about this specifically a number of times while I was covering this case.
Sure.
And I thought, and I've said this before, and I'm going to, tell it to your audience as well. I think that it was not the greatest way to go about it, presenting this defense by saying that she was framed. And also this third party culprit idea. The evidence is coming in. All that evidence that you want in for the third party culprit is coming in one way or the other. The only question is going to be, are you going to argue to the jury it wasn't Karen Reed, it was these 2 other people, instead of letting everybody know how the inadequacies of this investigation and how you got the ARCA experts. So we don't know who did it. Somebody other than Karen did it. When Alan Jackson said that, at some point, we don't know who did it. Somebody other. I thought that's very compelling. When he did that in that interview, that's a compelling argument. And when you say this framed, and you say that she was framed, it's almost, again, it's like you're shifting the burden onto yourself to prove that she was framed. Let's say the jury doesn't buy that she was framed, but the jury finds that there are some problems with the investigation. Well, they may feel like I have to choose, was she framed or was she not? The defense is saying she was framed. I'm not convinced that she's framed. There's a lot of questions with investigation. Maybe if they would have done it properly, they would have had some other suspects that they could have followed up, and maybe they would have got somebody. But to say that she was framed, to say that there's a conspiracy, it's funny. The difference between conspiracy and cover up, there's a fine line between that. I think that there's definitely evidence of somewhat of a cover-up, meaning that certain people were protected. That house wasn't searched. So if you want to include that in, your language of this could have been some sort of cover-up, some sort of, and not cover up as, we know exactly what happened, we're trying to cover up, but we're trying to protect certain people. And that's what's guiding this investigation instead of the search for the truth. So I think that exactly like you do, Brian, that I don't think that the stress should be, the emphasis should be on the framed part, or the emphasis should be on the conspiracy or the third party culprits. Who did it? Was it Brian Higgins? Was it Brian Albert? Was it Colin Albert? Who was involved? I think that that's a little bit distracting. And I think that if you just focus on how inadequate this investigation was, and how there's so much evidence and facts that are screaming reasonable doubt, especially when you have the ARC experts, which I'm sure we're going to get into soon, that I think it's much more palatable to the jury, and you'll get your acquittal, I think, a little bit easier that way. Now, the other problem is that it seems that they've been posturing this entire time this is a conspiracy. So at the trial, they're going to, to kind of suck it up and not argue what you've been telling everybody for the past, 3 years. It's just hard to do that. But I think just strategically, I think you're 100% right that they should kind of shy away a little bit from the conspiracy and just focus on how much there's just a mountain of reasonable doubt.
Yeah, and I think it's like a hard pill for a lot of us free Karen readers to swallow, because we know what happened. I mean, it just adds up in our head. And now to kind of shift, let's change the direction this time. And I think that the Reed team did learn a lot from the first trial, especially having the interview with juror Ronnie on Turtle Boy's show. I mean, I think that was phenomenal pieces of evidence, to get feedback from what happened in that jury room. But I want to go to Todd really quick too. And we were talking about this before the show started, in talking, and maybe this is why it didn't play well with the jury. Todd, we were talking backstage about, what happens when we grow up? What do our parents and, maybe our authority figures or our teachers in school tell us? Well, respect authority, respect the cops. Maybe that didn't play as well with the jury with this framed angle. Scott, Scott, I'm sorry about that. Todd, your thoughts on that?
Yeah, Brian, as we were talking offline, when we hear things like frames, someone being framed by the police department, or, the crooked cops, seeing law enforcement misconduct is not rare. But when we drill down to framing someone that's on trial for murder, we never see that, right? That's Hollywood. That's stuff that we see on the big screen. And so, to your point about trusting the police, it's ingrained in us, in our American culture, from we're old enough to engage and say hi to a police officer. And I remember parents would say, "Oh, if you don't behave, this policeman's going to arrest you." Yeah. And I would come back with, "No, right? Police officers are your friends." And so I was trying to shift that narrative, but I contributed to that. Trust the police, we're your friends. And so you grow up with that sense and that mindset. So, they've got so much to focus on with the inadequacies of the investigation. They'll get their reasonable doubt. They're right there. They don't have to embellish. There's a lot of low-hanging fruit for the defense.
Yeah, I definitely agree. I think all the puzzle pieces are there. It's just connecting it and having it resonate with the jury. It's not far off the tree, like you said. I mean, it's all there. Let's talk a little bit ARCA. And I do want to play a little bit of the video today, because Hank Brennan literally lost his about ARCA. And I've said this from the start. ARCA is the case. Once we heard those federal documents come in, once we heard this independent investigation of this team that was hired by the feds independently of the prosecution and defense, and they came to their conclusion, and knowing what they testified to in 1.0, I said, that's it. I mean, they've literally proved that Karen Reed's vehicle didn't make contact with John O'Keefe, and Officer John O'Keefe didn't make contact with Karen Reed's vehicle. I'm going to go to Martin here. When you kind of heard about this federal investigation, you heard these ARCA guys get up and actually testify. What did you think of all this kind of independent? I've never even heard of anything like that. The feds getting involved in hiring an independent team.
Yeah, I mean, I remember when I was watching the first trial, which I did watch. I know there's a lot of people popping up now talking about the case, and they really haven't watched the trial. But yeah, I have to remind everybody, I watched every minute of that first trial, and I plan on watching every minute of the second trial. So I'm going to be working insanely hard for the next 6 weeks, but it's important. Yeah, I remember I literally, because I've seen a lot of cases, right? I've been involved in a lot of cases, and you hear attorneys, create reasonable doubt when there's not one, or maybe they have some good arguments to make. 8 people left the house, they didn't see a body, give me a break. We've heard a lot of those type of arguments. You don't hear arguments like this. You don't hear arguments where we're going to have an expert witness show you that physics and science do not agree with the Commonwealth's theory, that you don't hear so much. You may have different opinions, different expert opinions, cause of death. Was it more this? Was it more that? But I remember watching that trial. As soon as I heard the ARC experts testify, say, she's going to get acquitted. I mean, she should get acquitted. And knowing that the only witness that the Commonwealth had was Trooper Paul, right away I knew that she absolutely should get acquitted on this case. And I actually was thinking, like, how can you as a prosecutor bring this case and understand your burden, that it's beyond a reasonable doubt, and think that you're going to convince a jury to just discredit the ARC experts, at least the entire jury. Now, what's discomforting is that we heard from Ronnie that some of the jurors were quite happy to discredit the ARC experts for no reason at all. For no reason at all. They had no good reason at all. All the reasons that we're hearing from the other side, that all their creative reasons that they didn't have, they had a very narrow amount of evidence to look at it. All those creative arguments, which I debunked on my channel a bunch of times. We didn't hear that from the jurors. From Ronnie, at least. Ronnie just said that, they just felt like she was there, he was there. I don't know. I guess she just did it somehow, and it was very discomforting. That's not what you want to hear. You want the jurors to base their opinions on the evidence. And the evidence was very clearly from the ARC experts, which was largely uncontradicted, that this interaction never happened. Now, what happened today in court was very interesting because we've been following this from the beginning, and everybody with half a brain understands that when you have the ARC experts testifying, that's going to create tremendous reasonable doubt. And Hank Brennan knows is going in, which is why he had to get his own expert, a real expert. And then we've got, so the entire time he's really trying to figure out ways to get rid of these ARC experts, so that, from the beginning, from the outset, he was trying to figure out how to strike the ARC experts, limit their testimony. And the latest version, which happened today, which is resulting in him, as we saw his demeanor today in court, he realizes that what he at least needs to do, what he really wants to do, is at least not let the ARC experts debunk his expert.
Yes.
Right. So that's really what he was trying to get at today. Like, if they're able to look at Welcher now and look at some of his reports and look at some of his equations, or I don't know what they're looking at, these, biomechanical engineers and the physics and science and math and equations and all that stuff. But if they're able to look at it and then tell the jury how this is completely not accurate, or they're fudging numbers, or he's creating scenarios that are impossible to exist in physics and science, that's going to completely destroy, the Commonwealth's case, which I've been saying from the beginning, because I've been on all types of channels where people are saying, well, would anything convince you not to believe the ARC experts? And I said, look, if Welcher can get up there and show very clearly why the ARC experts' math is completely off, and how their physics don't make any sense, and they're just making stuff up, and and he can actually show that clearly and completely annihilate them, okay, then I can reconsider. But if the ARC experts are going to do that with Welcher, well, then the case again is just going to be over as soon as the ARC experts testify. So he was very, very much, I think, today really wanting the judge to just not allow them to destroy and annihilate Welcher, which is what they're basically getting ready to do. That's what I'm seeing happen. This is definitely what I'd be doing if I was in Alan Jackson's shoes. And it seems like that's what he's doing. He gave Welcher's report to the ARC experts and said that. Now, another thing that I want to just point out, I know I'm going on a long train.
It's fine.
But another thing I want to point out is that there are certain things that, as a trial lawyer, you want to blow up as just to kind of like show like, oh, it's just not fair. It's just, and this is something that, he probably knew from the beginning. He's not getting rid of the ARC experts. Everybody knew that. I've been saying that from the beginning. The ARC experts are testifying. I mean, it's just such clear, blatant error to strike the ARC experts. They are absolutely going to be testifying. There's no question about it. Right. So, but if you start off your argument from months ago, then you can build up to a point where now you can make a whole theatrical display showing like, oh, it's just unfair. And I can lose my cool now because I knew this was happening from day one. You knew the ARC experts were testifying from day one. That's what happened. And you're just trying everything that you possibly can to get rid of them or limit them. And it's not happening. And everybody knows it's not going to happen. And it's not really not fair for them to happen. And as soon as Alan Jackson says that, everything that they did was expeditiously, they did everything as quickly as they could, there's no reason to limit them. So it just doesn't seem like it's going to work out his way, but he still needs to put on part of that performance. And also as a trial lawyer, that's something that you do is you take an issue and you blow it up to just make it look like it's unfair against you. And then maybe you'll get another win in another way. But this is what I saw today was, just basic, trial lawyering, and I don't think he's going to win on that issue at all.
Yeah, it's funny you mentioned Trooper Paul, and in talking about the defense really cutting down. I mean, that's what they've literally done in trial 1.0. I mean, the Commonwealth has present their experts, and AJ and team has just mopped the floor with exposing these experts. I want to go to Todd really quick about Trooper Paul in his glorious reconstruction of the of what he said happened to Officer John O'Keefe. And I find it very hard to believe that someone that didn't even go to this the alleged crime scene renders this edition of how he thinks that John O'Keefe was killed. Todd, your thoughts on that?
Yeah, I early in my career, I conducted accident reconstruction, and the investigation 100% of the time starts with a site visit, right? You have to determine, in the case of a fatality, where's the final rest of the body? Where was the impact and collision? If there was a vehicle involved, multiple vehicles involved, or maybe a fixed object like a telephone pole. Then you take that information and you draw it out nicely on a pad of paper. So that now becomes your field notes. Your witness interviews supplement your field notes. So this is just basics. This is even advanced investigation. These are the basics that law enforcement professionals will go and conduct. The nice thing that you don't necessarily need for a accident reconstruction investigation is the crime scene to be established. You can capture all the information just by capturing the final. Now, it's always nice to have photographs. It's always nice to have police officers there to be able to collect their statements, but you don't necessarily need the integrity of the crime scene to be intact. You can still perform that part of the investigation separate from whatever else is going on with the other investigative team.
Yeah, let's go to Hank Brennan. He completely melted down. We're gonna get a little bit of I'm gonna bring this video up here. We'll watch a little bit of this and we can talk about it, because I thought this was really the sticking point for me today. I'm gonna get a little bit of tail of the argument from AJ, and then we'll hear Hank Brennan for about 5 to 8 minutes, and he melted down today about ARCA, and I was just like, oh man, this is so good, because he knows this is his last ditch effort to argue this in front of the judge. It's all for show. It's all for camera. He knows he's not going to get his way, and he's angry because he knows this is the case. All right, let's hear a little bit here. I'm just going to double time it up so we don't spend too much. Let's do this. Here we go. Again, I want to thank Martin
Right. So,
and
Mr.
Todd
Jackson,
for joining
you're
the show
saying that the
today.
ARCA witnesses did not do anything, did not read anything, did not consult anything, did not try any additional experiments or come to any findings other than everything that's in that report.
That is correct. That's what we've been told. We have no reason to believe otherwise. Everything that they
Okay,
did.
wait. Before we do this, I just want to talk about this really quick too, because this just jogged my memory. This argument is about discovery. And the funny thing is that literally the Reed team constantly gets discovery dumped in their lap on a daily basis. I remember watching the interview with Ted Daniel, the part 2, when Karen is inside the SUV and they're driving around having conversations. She said, we literally just got a huge file dump of discovery, and there's like thousands of pages of documents that I have to go through. It's okay for the Commonwealth to constantly do this, but God forbid if they're not getting their way by the defense. And this is part of the argument here today. And actually, there was a ruling that came out. Judge Bev is going to give them, I think, an extra 2 days here to complete any reports and turn them over. But we'll go back here and watch this video because this was great.
Did everything they were asked to do, and all the data that they were provided upon which to base their opinions and conclusions is provided in the report, and it's all subject to cross-examination, both at the voir dire and at trial.
All right. And then subsequent to that, information was provided by Mr. Yannetti. And you have that all documented, whatever information the ARCA authorities now are working on is information provided by Mr. Yannetti or his file.
So there's two issues. I want to make sure I don't conflate these. Mr. Brennan mentioned a subpoena that Mr. Yannetti had received at his office.
Mr. Yannetti had brought it up in open court.
Correct. That subpoena was honored, as we had to, obviously, as Mr. Yannetti had to honor it. For every single NOD that we got from the Commonwealth, that was then submitted to the federal authorities.
When was that?
It was done periodically since the subpoena.
When did it start?
I don't remember the dates. September 1st, 2022.
Thank you.
I didn't remember the specific date, but it was very early on. So the Department of Justice, or the U.S. Attorney's Office, was receiving information pursuant to that subpoena on an ongoing basis. I want to make clear that's not information that was then going to ARCA. The U.S. Attorney's Office decided what information, and the FBI decided what information to supply to ARCA to answer their questions.
Do you know what information was provided?
Yes, it's in the report. There were 14 categories of items that were provided to ARCA, and they said that's all that we were provided.
All right, so then it's accurate to say items that are in the notices of discovery that ARCA does not list were not provided to them?
Correct. That's exactly right.
Okay.
They were provided a very narrow, it was a narrow scope of work, if you will, that did not include the myriad things that we were getting in NODs.
All right, then you started providing them information to fill in those gaps, right?
Once we received information from Dr. Welcher, for instance, we knew that we wanted at least to explore the idea of rebutting some of that information, from a biomechanic standpoint, and we wanted them to have basically a mirror image of what Dr. Welcher was provided.
All right, so when
that's
did you
what we provided to them.
When did you do that?
I want to say March 26th or 27th. I think it's in the motion.
And feel free, if anybody wants me to stop, so they can comment, just say stop, and I'll stop the video.
Provided all the additional materials to ARCA, including Dr. Welcher's reports and all of his findings, including the 140-page PowerPoint, et cetera. We wanted them to have everything that Dr. Welcher had, as well as Dr. Welcher's reports and findings.
All right, and you say that you will have that, you expect in the next 3 days or so.
Oh, I didn't say 3 days. I said I think we can count it in days, not weeks. So I would expect if there is something that we're going to receive, it's probably in the next week or 10 days, I would guess.
All right.
We are acting as efficiently as we possibly can, but we can only do so much, given the fact that we were only provided access to hire ARCA on March 26th.
All right, Mr. Brennan, I'll hear
Oh, here we go. Get ready, people. If you haven't seen this, and I'm sure everybody has. Oh, boy. Here comes the theater.
This is the very issue I've been concerned about since the beginning of this case. And I've made every effort to alert the court that I had a concern, in fact, that I anticipated this very thing would happen. When I began this case, beginning of October, end of September, my first analysis was of the past history of this case and dropping experts and information during trial. My attempt was never to preclude ARCA from testifying, never. But it was to preclude the defense from trying this case by ambush. And it was my...
Okay, I'm going to comment here. He said it was never to exclude ARCA. Okay, he's like, I want them to testify. Bring them on. But that's what you've been doing. Every motion that you have put in, you've just literally tried to exclude them a couple of weeks ago. And I love the comment here about trial by ambush. Okay, hello, Karen Reed. This is literally what you have done to her. Gentlemen, please comment. I'll go to Martin first.
Yeah, well, I mean, I think what he kept coming back to, and this is really what I think he's trying to portray, that there's some communications between the defense team and ARCA. Now, let's keep in mind that the defense team has said that they turned over all communications at this point. So I know that there was an issue about this, earlier on, and we talked about it ad nauseum. But now they've said we've given them everything, all communications, all email, all text messages, phone calls, whatever. We gave them everything that we have. Now, you can still ask ARCA to provide whatever they have, So what he's trying to portray is that, well, I only know what the defense tells me that they gave me. But maybe there's some, hidden communications that they're not turning over. He didn't say this, but this is really what he's implying. Yeah. That really some other communications that they're not turning over that ARCA would be required to turn over, and maybe we're going to find some sort of smoking gun there. And we're going to see how, they're really involved with ARCA and influencing their opinions or something, something like, to that effect. That's kind of what he's trying to create here, because they did turn everything over. I mean, they said that today, and, they turned everything over. He's not going to lie about that now, right? I mean, they've turned everything over, thousands of pages. So, what more really do you want? Well, we didn't ask ARCA themselves. We can ask ARCA, and then they should be required to turn over and bring documents, which is why he was arguing that we should not wait, till the day before they testify, because then they're going to already be here. They're not going to be able to provide these documents. These documents are probably going to be the same documents that they already provided by the defense team. This is just him trying to make a bigger issue about that nothing that's really there, and just trying to make it look like this is trial by ambush. I've been worrying. I know you're worrying about this from day one. Any lawyer with half a brain would be worrying about this from day one if you want to win your case. And yeah, of course, you'd pretend that you're okay with ARCA, testifying because you're just about truth and justice. But we know that if you're hired to win this case, and that you've got ARCA against you, you're not going to win this case. So you got to figure out a way to get rid of ARCA. And his avenue to do that was through these discovery requests and saying, oh, they can't comply, and then trying to limit their testimony and pretending like, I have no problem. I'm just not getting the discovery that I get. I mean, these are just regular, lawyer tricks that we play and we argue all the time. So he's just doing that. He's, pretending that he's much more, he's been worrying about this from day one, bringing it up all the time. And now he's all upset and he's fuming and he's going to make a big record about it and put on this theater. As lawyers watching this, we kind of all know what's really going on.
Yeah, I saw in my chat today when I was streaming it, a lot of people just smoke and mirrors, last ditch effort because this is the last hearing before trial is going to start. Todd, any comments on this here?
Yeah, Brennan knows how powerful ARCA's testimony was and will be. And if this is a way to prejudice him, he can't beat them on their credentials. He can't beat them on their analysis. He can't refute any of their testimony. So last ditch effort. Good luck.
All right, let's go back here and we'll finish up with Hank.
My primary concern, and that is why I filed motions from the beginning of this case. Your Honor must remember, I was filing notices of intention, notices anticipating, things that are not routine because I knew this very thing would happen. We had ARCA witnesses where I still do not believe we have had full disclosure. Regardless of whose fault it is, I still do not believe we have full disclosure. Not just for the basis of opinion, but regarding communications between the defense and ARCA. That's why I filed this motion for discovery. And when the defense responds, it's not in their possession of control. That's why these ARCA witnesses who've made representations to this court about not knowing the defense and the limited interaction with the defense, they need to be held accountable. That information should come directly from the ARCA witnesses if the defense can't or won't produce it. I believe there will be information that ARCA has if you order them to bring in all of their communications, email, phone call records, billing, and text messages. And if it exists, I would like to see it. I think I'm entitled. The ARCA witnesses provided a report that blurs the roles of the parties. I can live with that. I can accept that. The ARCA witnesses provide a report that does not have a lot of information about their study and notes. I can accept that because I have prepared for it. But what I haven't prepared for is for the defense to wait until the last minute, then move for a TUA request, which they know will take time, then provide information to ARCA on the eve of opening statements, and then expect to come in with new opinions and information and reports after we've already given an opening statement. It's not only trial by ambush. It not only takes away the Commonwealth's ability and right to prepare, it creates a disadvantage that information and argument is already made to the jury without complete information that they should have had. They could have retained any expert they wanted. They didn't have to wait for ARCA witnesses. They've had 3 years. They could have retained any accident reconstructions they wanted, but they waited. They moved with a TUI letter on February 7th, 2025. Anybody with experience, including the defense, knows it takes time. If they really wanted the ARCA witnesses, they could have moved in November. We gave Judd Welch a CV in November. We met our discovery deadlines, and they were hard. There was more we would have done or wanted to do, but we couldn't because we honored our obligations to the court and the discovery orders. We provided the discovery pursuant to the orders so that they would be held to the same standard. And now we hear they waited until February 7th, 2025 for a TUA request. And now they're giving new information to ARCA to come back and potentially give new opinions that we have no ability for our experts to evaluate. We have no ability for our experts to then go through and conduct more testing. This is the core of preparing for the case. They had that obligation. And so now to allow them to do this, it's not an aberration. This is a continued pattern from the last trial. They have their ARCA witnesses. They have their report. That is all pursuant to the discovery deadlines. To now let them change the rules and come in tomorrow, the next day, or 10 days from now and have new opinions after we've already told the jury our theory and our science and not have a chance to rebut it or consider it. I'll have no time during trial to sit down with the experts and assign them to review new information, new reports. I'll have no time to go back and reconsider the order of witnesses or the information we need or witnesses that we've decided we don't need in this case in scheduling. If it wasn't so obvious this was going to happen, I wouldn't be so upset about it. At some point, the defense has to be held to the same standard of discovery obligation. This isn't late notice. This isn't parachuting in. This is an effort they decided to make and wait until February 7th, 2025. Your Honor, I ask you to allow ARCA to testify, allow them to testify to their report, be confined to the report that has met discovery deadlines, and to produce the request that the court ordered regarding discovery of the information that we want. That's what I asked this court to do.
I feel like we're watching A Few Good Men.
Yeah, I mean, can you imagine this? I mean, this is almost like getting, Sallyport videos a day before trial. I mean, it's
Exactly.
it's so egregious. How can this type of stuff go on? But no, to be honest, I mean, you just heard in that last argument, that last few sentences where he said, "I want ARCA to testify." He knows ARCA's testifying. He just wants, really, at this point, he cannot have ARCA completely annihilate Welcher.
Yeah.
That's what he's trying to protect now. At least then he can make some sort of good faith argument to the jury that they should discount ARCA because his expert's better. But if ARCA gets a chance to destroy and annihilate Welcher, and that's what they do, well, then he's wasting his time. I mean, he'll get a paycheck, but he's not going to win the case.
Yeah, it's
even with, let's take ARCA off the table for a moment. The defense is savvy enough to be able to pit the prosecutor's witnesses against each other, right? Take, for example, the medical examiner. No one can say that a 6,000-pound vehicle struck John O'Keefe. It's absent. It's not there. So you can have the theater you want. You can grandstand in all these fancy legal terms. It doesn't change the fact that there's expected damage on his body is just absent. If your claim is she hit John O'Keefe with her vehicle, the damage to the body just isn't there.
Yeah, I mean, go ahead, Martin.
Yeah, you still have Dr. Russell. You still have that picture, which speaks a million words, as we were talking about, backstage. I mean, that picture alone, you just show the jury to the picture. How many times I've been telling you this before the show, but how many times I'll meet somebody who is not familiar with the Karen Read case, and I'll say, you ever heard about the Karen Read case? He says no. I say, okay, let me show you a picture. And I just show them the picture and say, what caused that? See if one of their first 10 guesses is a car accident. It's usually not. That's usually, and within the first few first few guesses are going to be a dog attack or an animal attack or something, like a barbed wire or knife, something like that. No one's going to guess a shattered taillight. So that's powerful. That picture is powerful. Dr. Russell's testimony, extremely powerful. So yeah, I mean, Todd McGhee's point is still well taken that, even without the ARCA experts, you still have a very strong case, a lot stronger than you find in some of these other cases where the jury will acquit someone.
Yeah.
So even without ARCA, I mean, you still have plenty of arguments, but like we said, ARCA's coming in. There's no question about that. And the only question now is whether they're going to be able to just debunk, annihilate, and destroy Welcher.
Yeah, no, I agree. And I was going to just say, like, Todd, you've seen probably many pedestrian accidents throughout your career. You've come to scenes where maybe a pedestrian has been hit, and probably at a lower level accident or whatever accidents that you've seen. In this type of case, I'm sure you've seen someone that's been hit or backed into and had multiple more injuries than John O'Keefe had. I mean, there was no lower extremity injuries on Mr. O'Keefe. We just had what was it? The ribs were cracked because of CPR, correct?
Resuscitation, right? Yeah, to try to revive him. Brian, I'll give you one better, and I never shared this with you. I was a freshman in high school, coming back from a basketball court, playing basketball with some friends. I got hit by a car. Guess what happened? I had bruises all over my body.
Yeah.
Now, it was a low speed, so it was something I could walk away from. But again, a motor vehicle, probably 3,000-pound vehicle, hit me on my bike. I fell off my bike. Wow. And there's injuries, abrasions, road rash. None of that is prevalent anywhere on John O'Keefe's body. So again, we love the ARCA experts. They're the best at what they do, and it's going to be great to hear them around in 2.0.
Yeah, I actually have a photo of myself standing next to the same identical model of Karen Read's vehicle, and where John was. I'm 6 foot. I think John is 6'2" or 6'3", and you know, just even where I would line up with that tail light, if it hit me, I mean, I would have had multiple bruising all in the area of where they said that this tail light made contact. I mean, it just doesn't add up. None of this adds up.
Did you stand with your arm out there like this? Did you do that?
Exactly.
Yeah, I should have been like this, right?
Yeah.
And then how do you account for the other injuries on his body? The laceration to the back of the head, right? If play out the prosecution's hypothetical, or Trooper Paul's scenario, the vehicle hits John O'Keefe, he pirouettes, lands 30 feet away. Well, in one impact, how do you get the injury to the arm, to the back of the head, the swelling and bruising under the eyes? I believe there's a laceration underneath the left eye. It just doesn't add up.
Yeah.
Yeah.
And
Well,
I'm sorry, Martin. Go
yeah.
ahead.
Yeah. I mean, that's why they're going to try to have some sort of expert say that the ground was hard enough. And I don't think.
Yep.
I'm
Hard
not
as a
sure if you
rock.
rule that the meteorologist can actually testify about that. So I'm not sure if they're going to have any experts say that the ground was actually hard enough, hard as a rock. That was one of the terminology.
Hard
You
as a
remember that?
rock.
Yeah, hard as a rock was the scientific term for how hard the ground was at that point. But yeah, I mean that's part of going to be the argument. Or maybe he hit it on a curb and then he rolled over, you know, another 10 feet or whatever it is. So yeah, I mean the whole scenario is so unbelievable that
And that's because the crime scene spoke to him.
Yes, it spoke to him.
yeah, well, there's always that.
Oh gosh,
Oh.
it spoke to me. I was just like, oh, this is not going to go. It's not going to be a very good day for Trooper Paul. What I do want to talk about, since we are talking about evidence collection, and Todd always uses this analogy of there's a lot of meat on the bone here. We just had the Canton audit complete, and they found in this audit that Canton was not following proper policy and procedure. And one of the biggest missteps that they found was the immediate roping off of the crime scene and taking proper photos in that very moment would be very, very helpful, to this investigation. I look at, and I've talked about this multiple times on my show, but I just want to raise this point to Mr. Radner here. Is there's a new documentary. I don't know if you've caught it. It's on Netflix, and they actually go through the O.J. Simpson case. And in, I think, episode 2, they basically talk about the OJ team. What do we have here? What can we attack? And I think this is a very strong point of the defense of something that they could use in this tactic as well too. Well, in that documentary, they talked about, we have all these hours and hours of footage of the news media literally out at Bundy watching them collect evidence, and how improperly they were collecting evidence and not wearing proper gloves and putting it in, proper sealed containers. We got something here. Let's attack it. And forgive me, I forget the attorney that actually did all that cross, but I remember when they got Mr. Fung on the stand, the lead part of the evidence collection team, they literally shredded him to death, and it worked. It convinced that jury. And I just go into, and I'm going to go down my list here, and I sent this list out today. We have red Solo cups that were used to collect blood evidence. We had Stop and Shop paper bags that were used. No photos of the immediate scene. The crime scene was not taped off. Potential witnesses were allowed to walk away and go back inside the house. A leaf blower was used to process the crime scene. Footprints throughout the entire scene. It was one of the first things I saw when they played that leaf blower video. It said there's footprints through this entire scene. Terrible documentation of witnesses in the situation, the handling of witnesses, and then obviously the Canton audit proved issues with policy and procedure. Gentlemen, what is this? Is this a strong point? Is this more meat on the bone that the defense can attack here, go after this non-collection or this poor collection of evidence?
Yeah, the inadequacies of the investigation speak for themselves. That alone in 1.0, I thought was enough for acquittal. There was just so many basic investigative steps that were not taking place. And you might as well include the lack of interviews from the occupant inside the house. It was asked why they didn't go in. It was asked of one of the, I believe, lieutenants from Canton PD. He said, well, we didn't have a search warrant. Well, what about exigent circumstances? How do you know there weren't other bodies? Exigent circumstance allows law enforcement to go in to a dwelling without a warrant. They could have exercised, or they could have just simply started with consent. And then
I mean,
there,
they definitely could have asked it. I still maintain that there was probable cause to search that house, and the fact that there was never even a warrant attempted to get for that house, I think is again another thing about this case where they're trying to protect their own. The fact that there's, this is, people are saying, it's a blizzard. What are they supposed to do? And how are they supposed to get to the evidence? The fact that there's not a cop car sitting outside of that 34 Fairview, you can't put up tape because of the blizzard. Okay, fine. Put a patrol officer there. Just have somebody watching over the scene.
That's right.
Like, that's so simple. It's so easy. And this way you can maintain the integrity of the crime scene. And here, just we'll just, leave it completely open, and anybody who wants can come across. Animals can come and start, who knows what can happen there, but the fact that there's not even a police car there. I mean, the Solo Cups is just like, again, it's just one of these moments where you're watching this trial and is this really happening? Like, they really collected evidence in Solo Cups and in a Stop Shop bag. Like, it's again, one of these, I can't tell you how many moments of this trial where like I just hit the back of my chair. Like you always hear about, the investigation wasn't done properly. And then you get some cool defense attorney will be able to try to convince you how there was, you should have followed up on this 23rd lead that was called in, and you didn't do that. And that shows how this investigation is terrible. We've heard those arguments. We're not talking about Solo Cups in those cases. Like Solo Cups, you got, the leaf blowers and everything that you went through is just like, again, it makes you hit the back of your seat again while you're watching this trial and say, is this really actually happening? And then you start to question yourself, is this prosecution really happening? And why are they so dead sold on trying to get a conviction on this case when there's so many problems with this prosecution? So like that also starts to creep in your mind. And that's why when you have other people and either people from other countries that are watching this, and they start saying, like, is this how the justice system works in America? Like, what's going on there? It's kangaroo investigations.
Yeah.
So, I mean, it's,
to piggyback on your earlier point about just putting a police officer there to preserve the crime scene. Well, that slows things down. There's nowhere in a procedure that says you've got to get this crime scene processed in 60 minutes, 2 hours, whatever. That allows time for your other resources. In this case, it was going to be the state police, and again, assuming a proper investigation was being conducted. But it allows things to be slowed down, and it allows the opportunity for additional resources to come in to conduct a proper investigation.
I agree. If you're just joining us here, I just saw a flux of subscribers come over from the Young Jerks. Welcome in, by the way. If you're just joining us here, we have my good friend here, retired veteran Mass State Police Trooper Todd McGhee, and also joining us from the YouTube channel, Brother Counsel, we have attorney Martin Radner here. And we've been obviously talking about the Karen Reed case and the hearings that actually happened today. I do want to segue here and talk a little bit about the Commonwealth again. And, the Commonwealth has been submitting motions to obtain the media statements from Karen Reed. We obviously know that she's been involved in some of these documentaries. Funny enough, the ID documentary, I actually was interviewed for that way back in March, but our segments got cut out and they allowed to bring in people for the Commonwealth. I have a question. Actually, I'm hoping Martin can help me here. Is how does that all work? I mean, I look at it as, okay, well, let's just play fair game here. If they're going to get a collection of these statements, I hit him, which I think is completely ridiculous because no one ever actually heard her say that. And wouldn't it just play fair on the defense's side to say, okay, if you're going to clip these pieces of statements and maybe put in a video presentation in your opening statement, shouldn't the defense be allowed to do that as well?
Okay, so I mean, first of all, I just will say, because I know people are going to be jumping on me, that there were some paramedics who said that they heard her say, "I hit him." So let's just, I know the position. I know all the arguments. We can talk about that statement in a minute. But I think what your question really more gets to is the question about all of her extrajudicial statements that she gave, her interviews, and all these documentaries. So is Hank Brennan now? I think this is your question, and then you'll tell me if I'm wrong or not. I think what Hank Brennan is thinking about doing is to cutting and pasting certain statements that seem very bad for her and playing those and introducing those into evidence, and then not allowing the full context of those statements in. What should the defense do about that situation? Is that your question?
Yes.
Okay, so this is where the rule of completeness. Okay, the rule of completeness is the following: if you have an extrajudicial statement by a defendant, and the prosecution wants to introduce that statement, then the way it works is that they have to introduce not just that statement, but if the defense requests, they have to introduce more context and all the statements that have to do with that topic. You can't just pick and choose by the prosecution exactly what you're nervous about. You're not allowed to do that. Now, you could in the opening statement say, we are going to play you, or you're going to hear that Karen Reed herself gave certain statements, and some of them include the following. They're allowed to do that. They don't have an interview. But when the presentation of evidence is coming in and they want, either this reader or whichever trooper is going to be reading her statements in, when that's going to be happening, then the defense, if they haven't already, I'm sure they will, either make an objection or make some sort of record that if you're going to introduce those statements, then you also have to introduce the statements where she said, I didn't do it. You also have to introduce the statements that say this. Now, it's limited kind of to the interview that they're speaking about. So if, for example, if in the Gretchen Voss interview, she said, I didn't do this at all, but she didn't say that in the interview, in the documentary.
Right.
In the documentary. So then you can't just pick and choose like that. It has to be the same person that you're talking to, the same, number of statements and topics that you're covering. Then you can make the argument that all of those statements have to come in. And then if you're the defense, you can actually just show the context, or if there's a retraction, if this was, she's explaining what she meant here, she may have said something, but we all sometimes just say things in conversation, then we have to correct it later. And that's what she did. So I wouldn't be too nervous of Hank Brennan. I mean, you may hear about it in the opening statement or closing arguments, but I wouldn't be nervous in terms of, the presentation of evidence, only hearing the statements that are going to be inculpatory of Karen Reed and not the statements where she's explaining and is more exculpatory. I hope that was clear.
Yeah. Do you think this is bait to try to get Karen Reed up on the stand?
I think that Hank Brennan is wishing she takes the stand, and there is no way in the world that her attorneys are going to let Karen Reed take the stand. And she'll probably tell the media that she wants to take the stand, and that she's dying to take the stand, but she's going to leave it up to her attorneys. But any attorney in America will tell you that the last thing that they need in this case is for Karen Reed to take the stand. Again, I know that there's different theories about this, but most of the time, most of the time, you just don't have your client take the stand unless you absolutely need them, and in this case, you don't need Karen Reed at all on the stand. You're just going to open up a whole bunch of can of worms. So no, this may be a way of baiting them, but the attorneys here are not going to get baited into anything. They're way too smart for this. Both of these, I think Hank Brennan's a good attorney. Also, I know people hate him, but I think he's an effective. He knows what he's doing. He's not a guy that's going to come unprepared. I know some people think he's unprepared. No, everything is prepared. He knows what he's doing. He's doing it on purpose. And you may not like it. You may think he's slimy. You may think he's, that's all fair game. But the attorneys, I think, on both sides are not going to be duped into anything. They're not going to be baited into anything. They know exactly how they want to try this case, and that's how they're going to do it. Now, of course, you always have to, deal with what comes up and think on your feet and things like that. But I'm telling you right now, Karen Reed is never going within 20 feet of that stand.
Yeah. And that was kind of my thought today. I was like, maybe they're going to try to bait her with these statements and have her get up and explain, oh, that's not really what I meant or what I said. And I was just, thinking, like, you just said, there's probably no way they're ever going to let her get up on that stand, because it could potentially get messy. I mean, it could. I mean, we've seen this stuff before. The Alec Murdaugh trial got really messy when he got up there and testified. He basically got shredded. So I was just like, nah. I'm sorry.
Don't forget that the depositions, I'm going to bring up Jen McCabe. Alan Jackson pressed her during her testimony about her deposition. Karen never made a declaratory statement of that she had hit him.
Yeah.
And memories are better when they're closer to the incident, to the event, right? And so those depositions are still at play, even in the second trial.
Yeah. And just like, we always hear this too. We heard it in 1.0, memories tend to fade. They don't get better as we go along. And I can only imagine, oh my God, the mess that it's going to be when these witnesses have to get back up and retestify. It is going to be, I think it's going to be a very choppy trial, a lot of stopping, a lot of, can you show me the document? I don't remember. I can't recall. I hope the sidebars get cut down, but I think that just Bev kind of runs her court like that and never really allows the attorneys to get into any type of rhythm. Martin, have you ever seen a lot of, kind of non-rhythm in a courtroom to kind of just let the attorneys go at it? I mean, it's constant stops. I mean, if we played a drinking game in 1.0, we'd probably be all drunk by the end of the trial.
Yeah, well, I mean, a big part of that is because she's not allowing you to state your grounds for your objection. So there's going to be so many sidebars, and there were so many sidebars in last trial. So it really breaks up the trial a lot. And I mean, any trial lawyer will tell you that when the other side, then the other lawyer is getting into a good rhythm with a witness, you got to stop that one way or the other. And if one of them is, one of the ways to stop that is by making an objection, whether it's has grounds or not. And if you got to go to sidebar, then that's even better, because you make an objection. Can we go to sidebar? And then you come to sidebar and you come up with some silly reason why you have to make an objection. The judge overrules you. But now the witness got to kind of, think about it a little bit more and is a little bit more careful, and you kind of ruin the rhythm of the other attorney. So yeah, I mean, you find this in this trial. There are judges that don't allow that. There are judges that kind of allow the lawyers to try their cases. And, but in this case, as we're seeing, and as we're probably going to see in 2.0, because Judge Cannoni is keeping with her same rule about objections, it's going to be a very broken up, many sidebars type of trial. And once the lawyer's going to get into rhythm, it's going to be stopped and cut off. And then that's what we have setting up. Unfortunately, that's how we're going to have to watch this trial.
It must be so frustrating as lawyers, like when that's happening. I'm sure you probably feel it sometimes when you're in court, you're just getting cut off all the time.
No, I mean, yeah, of course. When it ruins your flow, I mean, there's nothing more frustrating about that. But just watching this trial, I mean, just watching 1.0, I was just so frustrated that they can't just state the grounds of their objections. Everybody knows the difference. I mean, I shouldn't say everybody, but most trial lawyers know the difference between a speaking objection and objection where you're just stating your grounds. And the trial moves a lot more efficiently when you can just get up and say objection hearsay, objection foundation, overruled, sustained, move on. It doesn't really disrupt your flow as much, and you're kind of moving on. So yeah, it's very frustrating, and it's hard to watch.
Yeah, it was a super long trial. Todd, I didn't know if you want to jump in. Did you want to say anything, or?
No, just following all these different courtroom gymnastics, and we will, again, to Martin's point, it's how she runs her courtroom. We'll see a lot of this again. But again, the defense team is going to be a lot smarter this time around. They have a feel for the style of not just Judge Cannoni, but also going through all the hearings, not really seeing Lally have a central role this time around for the prosecution. But now you see, Special Prosecutor Brennan in place, and I think they get a good feel for his style.
Yeah, someone pointed out, I remember someone saying something the other day when they were still in jury selection. Adam Lally got up, didn't even introduce himself. You could just tell, like, he doesn't even want to be anything near. He probably doesn't want anything to do with this anymore. He's basically the coffee boy. Grab you some coffee and sit at the table. But you can literally see it on his face. My body language, when I'm seeing the body language, he hates Hank Brennan. He doesn't want to be here. I kind of felt that in the first trial as well too. He just didn't want to be there after this thing was really dragging on. Due to, him having to talk about the weather every 5 seconds and really slowing this down and asking all these witnesses, was it raining? Was it snowing? How was the atmosphere inside the waterfall? It was just ridiculous, these questions. But I wanted to ask this, and maybe we can take a couple of questions from the audience before we wrap up here tonight. Any foreseeable curveballs from the Commonwealth? Martin, do you see any foreseeable curveballs that might be shocking this time around, or is it kind of hard to say? We don't know.
Yeah, look, Hank Brennan is going to be throwing everything at this. So as we've been seeing, there's going to be moments, I'm sure we're going to be seeing them, where he'll get up and for some reason or the other have a problem with something and try to make some sort of novel argument that the defense isn't ready for, and try to get away with it. I can definitely see that happening. I think we've seen the way that he operates, and he's trying to win this case. And it's if the ARC expert's successful, like we said, it's stacked a little bit more against him, I think. And he's got a tough job, but I think he'll try to pull everything out. He's trying to get attorney-client communications. I mean, for God's sake. So he's trying to get everything. So he's trying to win this case in any way possible. So, I mean, if you're the defense, you got to get ready for any sort of curveball, or any type of idea that he gets in the middle of trial. I'm sure we're going to be hearing more arguments from him, how it's not fair, how, the defense is being unfair and trial by ambush, and, all these type of things. I'm sure we'll be hearing stuff like that. And maybe they're violating court orders. And, I'm sure we'll hear more of that. I can't foresee right now what it's going to be, but I'm sure we'll be hearing some more novel arguments from Hank Brennan about this trial.
Yeah, and real quick before we transition into Q&A from the audience, and just adding to the theater of it today, at the very end of the hearing, we saw Turtle Boy actually get brought up in the hearing. We had Hank Brennan getting up and talking about that, and Mr. Bradel was there. In saying basically my client's going to take the fifth. I think they kind of called out Brennan today. I think his tactic didn't work, in my opinion. And I think that was all for theater and smoke and mirrors to really try to lump Aiden into this and possibly keep him out of the courtroom during this, during the trial, so we can't report. But I wanted to ask you about the Fifth Amendment, because I saw a lot of chatter online from the trolls basically saying like, oh, Aiden's not going to get up there and stand, up for himself. He's pleading the fifth. He's not going to say anything. And, he must be a coward. It doesn't really work that way. And if you could explain a little bit how the Fifth Amendment works.
Yeah, well, I mean, this is something that I was talking about with Mark Betterow. Actually, I did a show with him maybe it was a week ago, or maybe it was a week from this past Sunday. We did a show together on Calling All Beans. It was the first time we actually spoke about this case. So we were talking about Aiden Carey, Turtle Boy, being on the witness list, and what Hank Brennan's trying to do, and he's done this before. Try to get these journalists out of the courtroom by putting them on the witness list and saying he's going to call them because witness intimidation. And also, this is also the part of the reason how he was able to get Mark Betterow not to be admitted pro hoc vice, if you remember that. And we were talking about this idea, and we were talking about that, and we both agreed right away that if Aiden Carney gets called on the then of course he's going to assert the Fifth Amendment. Like, that's like just any lawyer would have them do that. Why? Okay, two things. First of all, for all the trolls that are saying that, Turtle Boy can't stand up for himself, this isn't his case.
Yeah.
Okay. He's not being prosecuted in this case. He's being called as a witness in this case of Karen Reed, right? So you want him to stand up in his own case? Let him do that in his own case. Okay. Right. And then you can all troll him and say, oh, you can't even start up for yourself. Fine. Right. But here, this is Karen Reed's case. Why should he say anything that may damage Karen Reed and then also maybe hurt himself in his own case? He's gonna, if he wants to, let's say, testify in his own case, why should he give them two stabs at it? And lawyers are trained to make people look like liars. Okay. You can be saying the God honest truth, and we'll make you look like a liar. We'll make you look like you're trying to hide something. We'll make you look like you're saying a half truth. That's what we do. That's what lawyers do. So you never want to give for no reason at all, just to be called in another trial and another witness, another case that is not even you're being charged in, to give them another shot at another shot at this. So of course, the obvious thing, which is I was talking about Mark Betterow, we both agreed that of course he's going to be taking the fifth if he gets called in Karen Reed's case. Now, if he wants to stand up for himself in his own witness intimidation case, if that case doesn't get dismissed, which I think that a motion to dismiss is still pending.
It is still pending, yeah.
But if he wants to stand up for himself in that case, okay. And if he doesn't, then yeah, go ahead, troll him away. Then that's fine. That's all fair game. But any lawyer with again half a brain in his head is going to tell his client, you're not going to testify in somebody else's case. We're not going to give them more shots at this to make you look like a liar and then be able to use that transcript if you have to take the stand in your case. So yes, of course he's going to assert the Fifth Amendment. It doesn't mean anything, I think. And if he wants to, in his case, whatever decision he makes in his case, then you can go ahead and troll him away, no problem. But that's my take on it.
Yeah, I thought it was a lot of just theater. Hank Brennan, let's get him on the stand. Let's have him get up there and plead the fifth. We'll have it in front of all the cameras. I felt that was kind of the moment they were kind of working towards. But it ended up working out, and we'll just have to see what happens going forward. All right, everybody, you have two experts here in their respective fields. If you'd like to ask some questions, maybe we'll wait 5 or 10 minutes here and roll out some questions. Please just put a Q before your question. I'll pull them up on screen, and this is your time. We'll wait like 5-10 minutes here, see if any questions roll in, and we'll go from there. So we have a question here for Blurry Lines is asking for Todd. The feeling is Tully is the worse than Proctor because he was a supervisor. Your thoughts? Thank you.
Yeah, supervisors are just keep their subordinates accountable, and those communications included Sergeant Buchanan as well as Tully, and that whole string of trooper to sergeant to lieutenant. Not to mention, I believe there is some allegations that Tully interfered with the jury pool. All of those things are, if true, are inappropriate, and there should be some level of accountability there.
Yeah, I agree.
Well, let me follow up on that question because I think that one of the supervisors was claiming that he was on vacation when he saw those text messages, and that's why he didn't take any action. What was your reaction to that?
Yeah, so do your job. You're a supervisor. So once you discover them, and you come back into your line of work, you're still a supervisor, whether you were present or not, and that's just a poor excuse to try and dodge some level of accountability.
Yeah, I agree. We have a question for brother Counsel. It says, why is Bev allowed to sustain every single objection without an explanation?
Yeah, I mean, judges have great latitude to do what they want. They can sustain objections with explanation or without explanation. If you want to see how a judge is supposed to rule on objections, take a look at the Michelle Troconis trial, because that judge was fantastic. I loved watching that trial, even though some of it was very tedious and hard to watch, but the judge was amazing. Anytime he kind of made a ruling on objection, he explained his ruling. So it's very clear. First of all, he's confident enough to do that. Okay. Some judges are just not confident enough to really, they just kind of to them, or it sounds right, so they'll make a ruling on the objection one way or the other, but they're not confident enough with the law, the rules of evidence, the case law. And when you are a judge that's really confident, you have no problem explaining yourself on the record. And then when it goes to the Court of Appeals, go ahead. You've got my explanation, you got my basis for the ruling. You want to reverse me, go ahead. And that's what that judge did in Michelle Troconis' trial. In this case, you don't really find that as much, which is, I think, that's just the way that she wants to run the courtroom. It could smell a little bit like, she's just not as confident of her rulings. And maybe she's just, she's doing it more on reaction and more feeling, which many judges do. But it's another thing of this trial, which would be very helpful to everybody. And which is why I think some lawyers, even when I'm watching this trial and I hear an objection, I hear a ruling, I'm not sure what the basis for the objection was. I'm not sure what the reason for the ruling is. So, sometimes we're just as clueless as you as to this, and it would definitely help. And unfortunately, again, it's just another part of this trial, which makes it more difficult to watch.
I'm gonna pick through this one. I'm gonna pick through some of the questions, but this is a really good one, and I want to get everybody's thoughts on this one. Yes, Proctor, no longer Trooper Proctor, now just Michael Proctor. So will Proctor testify? If not, how will they introduce him? And the thing that's really odd, and I sent this article to Todd McGhee, he's still currently post-certified, correct? He did not lose his post. So he can actually, according to this, he can actually get another job. That's crazy.
Yeah, Brian, looking at that article, it kind of contradicts itself. It talks about how Post is retaining his certification.
Okay.
However, it says grounds for decertification is if an officer, one of the grounds is if an officer is found to be biased. And that was the second charge from the state police trial board that he was terminated on. So I think I've got a gut feeling that that's not over and done with, that we may see Post way back in on this, on his status.
Well, thank you for that clarification. So I apologize. I got that wrong. I'm going to go to brother Counsel here. Will he testify? And how do you think he'll be introduced?
The answer to the question is yes. He's going to testify. There's no questions asked. He is going to testify. The question really for you is whether the Commonwealth is going to call him. Because if the Commonwealth doesn't call him, the defense is absolutely going to call him. I've been saying this for months. Of course, you were going to call him if you're the defense. And I think Alan Jackson even said that in open court, that if the Commonwealth does not call him, then the defense is going to call him. He's absolutely going to be called in this case. Okay, let's just put that to bed. Now, if you're Hank Brennan, then you call him. Okay, if you're the prosecutor in this case, you call him because of you don't want it to be that you wanted to distance yourself from the lead investigator in this case and then wait for the defense to call him. It looks like you're not so happy with him. You might have something to hide. So no, if Hank Brennan is a good trial lawyer, which seems like he is, he's going to call Proctor. And with all his blemishes, it's just something that you have to do in your case. The same reason that in your opening statements, what you're supposed to do, and this is what I've told my channel a bunch of times, is you have to also embrace the weaknesses in your case. You have to talk about the weaknesses in your case. You're going to have to not just talk about the strengths of your case. You say you're also going to hear evidence, that Karen Reed said to some paramedics, I hit him. You're going to hear that, but you're also going to hear that she was hysterical. Also going to hear that she was in a panic. You're also going to hear that she was filled with grief and anxiety and she was blaming herself. You're going to hear a lot about that, but you also have, the point is that you have to embrace the weaknesses in your case and still show the jury how you win the case. So the smart move here, again, is for the Commonwealth or Hank Brennan to call Proctor, but one way or the other, he is absolutely testifying.
Yeah, and I said this too, that he has to get up there and testify because, let's just say at the closing argument, the defense closing argument, they could just turn and say, and look, they didn't even want to call the lead investigator that had these nasty text messages about Karen and the proposed of documenting all this, doctoring this evidence. They didn't even want to call him and expose him for that. I mean, it would be great in the closing argument for the defense. Let's just take one more here and then we'll wrap up this evening. Again, I want to thank these two gentlemen for joining the panel this evening during this live show, talking Karen Reed with us. And we'll just do this one last question here before we wrap it up. So it says, for Brother Counsel, how can Karen's attorneys best respond to Hank when he tries to use Karen's interviews against her?
Okay, well, again, like we spoke about earlier, the number one thing is that you have to make sure that the statements that don't just look bad for her also come in. So you have to argue that all those statements have to come in under the rule of completeness. And then number two is that I don't think she's going to say anything. I mean, I don't know all the statements that she's made. I didn't see the more recent docuseries on whatever it is, HBO Max, whatever it was. But I'm sure that you can cut some of the statements to make it sound bad. But I don't think there's going to be any moment of truth where she's saying, I really did this. I don't think we're going to see anything like that. So what we may hear is how maybe she told somebody I hit him. Maybe she did tell the paramedics I hit him. I don't know. Again, that doesn't bother me that much. I think even the side that is anti-free Karen Reed, I think they also understand that the fact that a lady in a moment of shock and grief would blame herself and say things that are not true is not an admission in any way. So I think just number one is that you have to make sure that the full statement and the full context of the statement comes in, because I'm sure it's the full context is helpful to Karen Reed. And then I don't think you're going to see any smoking guns. So as long as you just explain everything, how it makes sense that she made certain statements and how all the evidence in the case still points to the fact that there's just a mountain of reasonable doubt here, the conclusion still has to be an acquittal.
Yeah, before we wrap up here and get final thought for either one of you, I just want to kind of drop this and ask you, do you think that Proctor pleads the fifth when he gets up?
Well, I don't think he can. I don't think he can unless there's some sort of crime that he can be associated with some of his comments. So if he's going to try to assert it in some way, like if there can be some sort of obstruction of justice, if you can figure out some way, but again, it's going to look so, he's not going to plead the fifth for everything. So, it's going to absolutely, we know how well that did for Furman in the OJ trial.
Shades of Mark Furman. Here we go.
Yeah. So it's not something that he's going to do at all. I don't see it ever happening. It's not something to be worried about, I don't think.
When you say it can't get worse, that would be an opportunity for it to get worse.
Exactly. All right, let's give a final thought here. I'm going to go to Todd McGhee first. Todd, what do you think? Tuesday, we're going to start Karen Reed 2.0. your final thoughts on this. And I know that you'll be joining the panel here and having discussions throughout the trial with me. I appreciate you on that, and I always love your insight. But your final thoughts here on tonight's show.
Yeah, Brian, thank you for having me on. And Martin, a real pleasure being a co-panelist with you tonight. It's great to meet with you, great to work with you, and love the work you're doing on Brother Counsel. So keep up the good work, my friend. You know, here we are, right? This was long awaited. Fortunately, the jury selection went through, I think, relatively smoothly and expeditiously. And so, you know, once they get through these last sets of motions, we're ready to go with opening statements. So I think it's going to be an interesting trial. I think a lot of the angles that that Brennan is going to bring, that Karen's team is just going to have to be laser sharp and focused to make sure that, you know, that kind of that style of throwing everything against the wall and seeing what stick, they're going to have to be on top of that game. So Brennan's very savvy, very good at what he does. And so, you know, I think it's going to be an interesting ride to see how 2.0 plays itself out.
And we'll go to Martin from the Brother Counsel YouTube channel. Your final thought here, Karen Read 2.0.
Well, again, first of all, Brian, I want to thank you for allowing me on your show. This is the first time I'm on your show. I'm sure I'll be on many other times also. And also is, I think, our first time with Todd. And Todd, has been a pleasure as well to talk to you and hear your expertise in what you do. So like we said, we need more eyes on this trial. We need experts on this trial in each individual field. And it really helps, I think, bring this down to the level of people that are not, you know, experts in specific fields. And I think that's what this case needs. I do want to make a comment also, Brian and Todd, I hope you don't mind, but I saw that there were some comments about the beards that we all have beards on this panel. Some people like beards. Oh, there we go. Triple beards. Yeah, there it is. And we're not afraid to show it, even though we all got our little white hair coming down, you know, Brian, I don't mean to date you, but I actually just had a big birthday. So I know a very easy way to get rid of it is just shaving it off, but no, you gotta sport the beard one way the next. And if it's going to even show some of your age, well, then I guess you just got to do it at this point. So, but yeah, I mean, I think that this trial is going to be very different than the first trial. There's going to be a lot of, you know, same witnesses and similar things, but I think, you know, in case you think that this is going to be, you know, just another run through of trial 1.0, I think you got a whole nother thing coming because, you know, there's a lot more information that the different attorney, you know, Hank Brennan's a different attorney. There's just much more, like you said, more meat on the bone that we're going to be seeing in this trial. And I think from the opening statements through the closing arguments. So we know, for example, that Alan Jackson's doing the opening statements. I guess the verdict is still out. Who's going to be doing the closing? I'm assuming people are going to be thinking that that's Robert Alessi. So the opening statement I think, are going to be a little bit different. I heard that they're only having one slide. I'm a big slides guy myself, so I always like to show visuals to the jury as much as I can. I think that the Commonwealth's going to have a lot more visuals. Maybe it was like 20 or 30 slides or something. I think that came out in today's hearing. So yeah, but still, it's going to be, you know, Alan Jackson presents very well. You know, Hank Brennan seems like he knows how to present very well also. So it's going to be a very interesting trial to watch again. 2.0, I think it's going to be very different, like Todd said. And yeah, I mean, Tuesday, let's go. I mean, everyone's itching for this trial to start. The Jewish holiday is going to be over. I'll be back in Michigan. I'll be ready to live stream it from Brother Counsel Studios also and doing my recaps. And I'm going to be working like a dog the next 6 weeks. I'm just telling you, you know, so the calm before the storm starts now, I guess. You got a few more days and then you're just going to be working like crazy. So maybe my wife will see me, you know, a couple times within the 6 weeks, but you know, I'm getting ready. I'm all ready for the work. So bring it on.
Yeah. And by the way, the gray hair, that's wisdom. That's wisdom. That's wisdom. I want to thank both of these gentlemen tonight for joining the panel here on Let's Talk Live. My good friend, Todd McGhee, retired Mass State Police. And then, of course, we have attorney Martin Radner from the Brother Counsel YouTube channel. You can check him out there. I'm going to have my moderator drop the link in the chat. Please get subbed up to him. Let's get him up into the subs. He does great work over there. And it's been a real pleasure having him on the channel. I'm going to let these gentlemen go, and then I'm going to take a minute or two to close out shop here, and then we'll get ready for our next live. But again, we're all anticipating on this channel. I know everybody in this chat for Tuesday to hear what those opening statements are going to be like. and it's going to be one hell of a trial. And I know everybody's going to be tuning in. So, gentlemen, thank you so much again for joining. I appreciate your time. Martin, please, I'd love to have you come back and do this again sometime.
Looking forward. Thank you so much.
Have a good night, guys. Thank you.
Take care. Bye-bye.
Remove myself. Whoops. What I want to do here is just go back to the super chats here that came in. Blurred Lines, thank you so much for the $5. Said, first time here to see you again. Amazing guests. No offense, LTL. You smartly decided to have them on. Yes, I did. And it took me a little while. But we got it ironed out. Jersey Jen, thank you for gifting the 1 membership. Kelly's been a member over here for 7 months. So thank you for your continued support here of the LTL platform. Goodman's always dropping in 1 membership. I love that. Thank you and welcome a new member. Lady Los Sandra, it's been a while since we've seen you. Channel moderator, became a member of the channel. Thank you for being here. I always love seeing you in the chat with your wrench. And then we had, I Gotta Know, $5. How about the Buffer folks singing the national anthem loudly while Karen Reed walks into court each morning? Legal. Who gives a shit? Let's do it. Let's go. I love it. I love it. I love it. Fancy Facts says, when it comes to picking up the alternate jurors, can the defense ask Jim to see them on the bingo balls? Thank you so much for the 5. I appreciate it. Lady Law with another 5 says, Brennan's confrontational behavior with ARCA, legal precedents and principles should we consider in analyzing this situation? We're only going to find out when this trial starts, of course. And then Stacy blasted up with a $20 super chat. Thank you so much. Says, handsome crew, triple beards. Todd is in the movie. Was he in the movie 7? Have you ever seen anything like this? No, that was Morgan Freeman, but he does look a little bit like Morgan Freeman with that beard. I love it. I love it. All right, everybody. I love you all so much. I hope you enjoyed the show tonight. Please make sure to like, share, and subscribe. Comment down below after the show posts. And gosh, what a great panel, right? What a great panel. And I look forward to doing it again with those gentlemen. All right, everybody. I will see you soon. Have a good night. Tuesday's going to be the big day. Let's strap in and make sure that we continue to support and free Karen Reed. Have a good night.